And we are live on YouTube. And I will let everybody in. Ready? Here we go. Good evening, everyone. If you're just arriving, this is the Renters Alliance Renter Town Hall. We'll get started in just a couple of minutes, just letting everybody in the door on Zoom. Takes a couple of minutes. Welcome. Again, if you're just arriving, this is the Renters Alliance Renter Town Hall. We just got started. Takes a couple of minutes to let everybody in the door. Thanks for coming. We'll get started in just a couple of minutes. If you're just arriving, Renters Alliance, Renter Town Hall. Takes a couple of minutes to get going, but welcome to all of you.
You're not on mute. Okay, thank you.
Wait another minute till we hit the magic number and then we'll get started. Okay, let's get going. Good evening, everyone. My name is Matt Losack. I'm the co-founder and executive director of the Montgomery County Renters Alliance. Tonight's Renter Town Hall will focus on two areas in particular. One of interest to many renters is about towing and what is legal and what is not. Illegal towing is usually often called predatory towing. And then we'll also give an update on the COVID rent relief program and what's going on with that. And then the Renters Alliance staff will, of course, take questions and concerns either for any of these two issues or any other issue affecting renters. For those of you who don't know us, the Renters Alliance is the first and only regional nonprofit dedicated exclusively to renter outreach, organizing, education, and advocacy. If you're having issues in your building or individually, we're here to help. We're also very pleased to help organize tenants associations or strengthen existing tenants associations and deal with all manner of problems, as well as to guide people to resources that are available in the county and the state. So please contact us if you need our help. You can contact us at info@rentersalliance.org. Let me give you a couple of larger picture pieces of news. One is that we are seeing rent stabilization has not been passed in Montgomery County. And hang on one sec. Somebody has come into my apartment. Hang on one sec.
Can you put the info address in there? For some reason, I'm not able to.
Well, that is very strange. Somebody just arrived, came into my apartment to attend the meeting.
Oh my.
Okay. I guess our word is getting out and about in ways I've never expected before. Back to what I was saying. So, and by the way, nobody's supposed to come into your apartment without 24 hours notice. We'll put that in there. So the rent stabilization bill, which was presented by County Executive Mark Elrich last May, was to be heard in July. The council determined not to take action on that bill, so there is no rent stabilization extension. The last one, the emergency rent stabilization bill, expired May 15th. And so there's nothing in place right now. We were told by the council that they might reconsider it this month. So far, no action has been taken. We are seeing double-digit rent increases. If you have received a rent increase that you believe is excessive, we urge you, you can contact us. We'd like to know about it. You can contact us at info@rentersalliance.org. But we also urge you to notify the Office of Landlord and Tenant Affairs. You can notify them at olta.intake@montgomerycountymd.org. OLTA, Office of Landlord and Tenant Affairs, .intake@montgomerycountymd.org. They've already received about 90 complaints of excessive rent increases with an average rent increase of 21%. So these are very excessive and are likely over time to price people out of their homes. If there's going to be a policy solution, the policymakers need to see that this is not anecdotal, but actually a systemic problem across the county. And so having these examples is going to be very, very important. David, we are also in the courts every week, and our outreach coordinator, David Mullins, will go in there to assist renters and direct them to Health and Human Services staff and to legal services that are available in the court. David, what are you seeing in the courts now?
Well, they were there today again HHS staff to upload any documents. But what we saw today, Cecil from HIP was there too today. They're just about 1 in 10 tenants were present, so there were a lot of default judgments, meaning that just for failure to pay rent, if you don't come as a tenant, there's a judgment for the landlord. But still the right of redemption exists, and those folks, there were still a lot of low judgments for 1,000, 2,000 and less that could definitely be dealt with if the tenant is able to get rent relief.
Mm-hmm.
That's what we're hoping.
Understood. And I understand that we're seeing dockets still in the morning of about 500 and in the afternoon of about 500. So as we put in our newsletter, we were talking about standing room only in eviction court.
Well, yeah,
there is no longer a delay in processing eviction requests. Is that right?
Yeah, and then again, like not as many dismissals as I'd seen before. So just a lot of the cases went forward, whether the tenant was there or not today. Yeah.
So we've also seen a doubling, if not tripling, of the number of evictions that are taking place each month from about 6 months ago. Part of this is due to the courts having been closed until last April, I think it was, or March. Then they reopened and we're dealing with a long backlog. And then now they're full bore on people who are still behind in their rent. So we'll be talking about the COVID rent relief program a little bit later and other resources that might be available to struggling renters, as well as your rights in general. But I'm also pleased tonight to get to our first topic and to just introduce our special guests. We have with us at least 4 decades veteran of the Office of Consumer Protection, the director, Mr. Eric Friedman, along with his staff investigator, Bernardo Vega. The two of these gentlemen have a long experience in dealing with the evolving policy issue of predatory towing in our region, and we are very grateful for their expertise. And as many of you know, apartment communities suffer from some of the same confusion over towing that many commercial properties also see. So we welcome Mr. Friedman and Mr. Vega to give us an overview of what is allowed to happen, where we've come from, what's not allowed to happen, and what to do about it. Eric?
Well, thank you, Matt, for the great work that Renters Alliance does in so many different aspects, and for the opportunity to share information with all the the residents in Montgomery County. We probably, I know we're all thinking and sharing and sending some positive thoughts to the tenants and property owners in Florida. I know they're going to be having a rough night tonight. And so we certainly want to acknowledge that. Let me just quickly say before I forget, that our office, the Office of Consumer Protection, is a law enforcement agency. It was established over 50 years ago in Montgomery County. We're the only standalone office, local office in the state of Maryland. And towing is a big issue for us, and we're glad to talk about it. We actually do more than just towing. So all residents, whether they're property owners or tenants, if they have other types of consumer problems, we just hope that they will reach out to us because we are there to provide a service. But Matt, as you said, towing is a huge issue, and it's a difficult one because it's one in which you really have to strike a balance. And Bernie Vega, as our investigator, is probably the person who handles most of the complaints in our office, and they are difficult to handle, that is for sure. What we're talking about is really just having a situation that is, we're hoping not to be predatory, because unfortunately, that is part of the problem. There's a long history to the law that Montgomery County has. It's very complicated. It's very confusing. It's one of those laws that you just can't read once and remember it. It's constantly going back to it and trying to reread sections. And last night I looked at it again and found things in there that I hadn't even remembered. So it's a difficult situation. What we're trying to do in Montgomery County is to seek a balance. Because if we had no rules, there would be chaos in both our shopping centers and in our residential parking lots. But at the same time, we want something that's fair. And this law and towing was never designed to be a moneymaker for certain towing companies. It's a complicated issue. And in fact, we have had lots of media attention on Montgomery County, both national media attention, local news, New York Times, you name it. There's been stories about Montgomery County and towing in all forms of media for many, many years. And it was also the subject of a $24 million class action lawsuit that was brought regarding one particular company. And Matt, thank you for putting up on the chat some videos that people may want to take a look at. We have these on YouTube as well, but it's very handy. There are a couple of videos that are really worth watching after this program. One in which in the local news story, there's just great footage where someone who was running really a predatory towing company is caught on camera and asked if he's the owner, and he actually has the audacity to say, "No, I'm not even the owner of the company." It's just classic 60 minutes video, and it's worth watching.
Love it when you catch them red-handed.
Yeah, it is really pretty amazing. But again, let me just put things in context. I've got the 15-page law in front of me, but we're not going to want to go through it line by line, just some of the basics. And keep in mind, the best analogy for writing this law would probably be if you have a teenage son or daughter, and you had to sit down and write for your teenage son or daughter everything that they need to do and everything that they're not allowed to do, and put that into one document, because that's in essence what this law is about. It tells the towing company exactly what they have to do before they're allowed to tow a car. And then it has a long list of things that they're not allowed to do. And it's all trying to be put into one contract. I can say that there is no perfect such law, and there never will be, unfortunately. And all we can hope to do is to edit it and make changes as things go along to make it as close to perfect as possible. And I'm guessing that there's probably no one who's watching this who hasn't either been towed or at least know somebody that has been towed. It is one of the most frustrating things that could possibly happen to consumers. It's absolutely a strange animal because it doesn't happen anywhere else in the marketplace where someone can take something that belongs to you, take it away because they believe you did something wrong or have violated the law. And in this sense, the towing company is really the judge, jury, and jailer. Because they do all three things. The towing company will then look at the vehicle, decide if it's in violation of some rule. They will decide that it's appropriate to tow it, and then they will keep it and hold it ransom, in essence, until payment is made. So it's a very bizarre thing. In most cases, if you think someone did something wrong or owes you money, you have to go to court, go through due process, and before you can take any action. But that's not the case with towing in general. And then it's also very complicated, Matt, because we have many different types of towing. We have towing of a parking lot in a commercial section. We have towing of residential property. We have police towing, which is again different when you're parked on the street. And then we have requested tows when we are on the beltway, we break down, and the tow truck guy is our hero, and we want to hug and kiss him because we want to get off the beltway. So they're just
not sure if we'd go that far, Eric, but I get it.
So that itself makes it very, very complicated just to understand. And so what this law is just got all sorts of requirements. I can run through a couple of the highlights, and then Bernie can tell us a little bit about the kinds of complaints that we have. The bottom line is our office is there. We license and register all the towing companies. We also license all the auto repair shops and new home builders and other industries as well. But we license all the towers, and they have to have insurance. And only a very few of them engage in what would be called predatory or non-consensual towing. This is tows in which you didn't request it. And so what we're familiar with is the primary rules are that there has to be signage. And in a parking lot of a residential unit, there has to be signs that tell the consumer, tell the tenant, the people who have cars, what the rules are with respect to parking there. And this typically becomes a long list, difficult to sometimes read, difficult sometimes to understand. And the statute provides exact information as to how big the sign has to be, what exact size it has to be, where it has to be posted, about how many signs, things of that sort. And there's just a long list of requirements, such as when they do tow your car, they bring it to an impound lot. That lot has to be open 24 hours, 7 days a week. In addition to that, it has to be well lit, both in daytime and in the evening time. There are things like the towing firm has to call it into the police department before they actually leave and conduct the tow, because they don't want police officers running around looking for vehicles that the consumer thinks have been stolen, when in fact it really just has been towed. And there's just absolutely an unlimited amount of sort of provisions in this statute, including that they have to take photographs of the situation. It includes that the property owner, the landlord, has to have a contract with these firms to do certain work. It requires that the property owner has to authorize the tow, except during the middle of the night, which is typically 2 a.m. The statute says from 2 a.m. to 9 a.m. They have to have something called a drop fee, or if you catch them in the middle of doing the tow, they have to undo it or only charge you $25. Montgomery County sets the rates for how much it costs, how much they're allowed to charge for the tow, and how much they're allowed to charge for storage once they bring it to their lot. It talks about the fact that they're not allowed to have what are called spotters, or a monitor or a patroller slooping around. Before, the worst case is when they actually hide, and this is something that was going on for a while, hide in bushes and swoop in within seconds to tow a vehicle, even if you're just running across the street to throw something in the trash, or to go to an ATM machine, or grab a donut. And so things that in civil life we would think are not fair. That was even part of what was happening when things were at their worst. The law is enforced by both the police department and our department. So let me, there's so much more we can say. I know you have limited time. Bernie may want to chime in and talk about the kinds of complaints that he runs into, or what he does when he gets a complaint. Might be even helpful.
Can I ask one thing before Bernie, before
Sure.
you jump in?
Sure.
That comes up so frequently, Eric, is that you mentioned the authorized tow before 2 a.m. What does the authorization look like? My understanding was that the owner, the property owner, or the one requesting the tow must fill out some kind of piece of paper?
There has to be a written authorization. And so you're absolutely right. There's got to be something in writing. Now, it used to be only a piece of paper, but now that we have, electronic technology, we've updated that to it can be an email message and things of that sort. And I know, Matt, this is an issue that you've been involved with for a very, very long time. I look back in my records and I see that most recently, I remember seeing something back in 2019 where you were speaking with Council Member Tom Hucker about some of the things that were upsetting you and your organization, about things that were happening. So this is an ongoing situation, and we are, working as best we can. But keep in mind that we really want the property owner, want there to be a real problem with parking and not just a moneymaker. Where it's a bounty system, where we have some towers that are not responding to a true parking issue, a parking problem, but they've found out that there's a bounty, and then they can just run around finding a car. Because what's very strange about these contracts is when the property owner hires a tow truck company to patrol or to do the towing on their when necessary, they don't pay that towing firm anything. The only money that the towing firm gets is when they charge the owner of the car. So it's a very odd situation to think that you would, call a plumber and a plumber wouldn't get paid unless they found something wrong with the plumbing in your house. So
Because we found many tenants who are being towed from community parking lots for all of the reasons that you mentioned and for some nonsense reasons, but that there's no authorization that goes with that. And people don't realize that they then have a right to complain and address it. I guess that kicks it over to Bernardo.
right, but that's it. It is a cat and mouse game. And Bernie plays it better than anyone because he gets the complaint and he then has to start one by one. He'll tell us in a sec right now, I hope, the kinds of things that he looks for when the complaint first comes in.
Thank you, Eric. Thank you, Matt. I appreciate it. So it's exactly like the boss says. It is a cat and mouse game. When the question of time and authorization comes into play, what I normally like to do before I do anything is take a look at the documentation. On that documentation, there's certain technicalities that must be there. If they're not there, that's a violation right before we start anything. Then if, for example, I recently worked on a case where an individual was towed on New Year's Day when everything is closed. And I was expected to believe that authorization was given. So before approaching the tower, I went to have a nice chat with the property and said, who authorized? Please explain to me, how does towing work? And more times than not, in some situations, I'm told, well, the towers take care of everything. That right there is a huge red flag. At that time, I provide them a copy of the governing statute. In Montgomery County, it's a 30C. Okay. I educate the property or the property designee as to what's expected of them and what's expected of the tower, review everything, ask to see the log. The log is for at least 12 months. The property, the tower is supposed to keep a record of all authorized tows that came off of that property. As we see before, it used to be a paper. Now we see it more moving towards email. That's perfectly acceptable. But as I said, in this particular case, it happened on New Year's Day. Right off the bat, the leasing office said, sir, we were closed on that day. There was no one here to authorize that tow. So then, once I had that in hand, I had the point of contact of the person who's supposed to authorize the tows. I approached the tower They said, oh, well, it was pre-authorized. They asked us to. Really? Because I already had a nice conversation with your contract holder. We need to sit down and review this case a little further, if you don't mind. And ultimately, a refund was provided and action was taken in reference to the tower not complying with what is expected of them. That is what I'm starting to see more and more of, in which a representation of authorization was given. You look at the time, you look at the day, and it's impossible. How? If the leasing office is closed, if everyone is at home asleep at 1:30 in the morning, 1:30 in the morning, you still need a sign off. Who signed off on this? And that's where you have to go line by line in the statute. And on the documentation, the tow slip, you literally have to go line by line to make sure it is fully compliant. And if it's not, we have issues. Okay.
Bernie, do you find that many tow truck drivers will try to get out of it by getting retroactive authorization?
Well, see, that's where the cat and mouse game comes in. When you look at the documentation and you read the statement by the constituent, you piece the timeline together. This happened, chain of events. When happened? When did it happen? How did it happen? And what's a likely scenario? So instead of just contacting the tower immediately, you do a little bit of homework. You do a little bit of legwork first, so that if you ask a question, you know a good answer to that question before it's even answered. So, like I said, New Year's Day, a tow occurred. Well, most everything's closed on New Year's Day. Who's going to sign off on anything? There's no designee present. The office is closed. Security guards are off. You're trying to convince me at 10 o'clock on New Year's Day, someone signed off on a tow? So I went to talk to all the people involved. I was given a hard no. That's impossible. The tower said, oh no, here it is. This person signed it. Who's this person? Because I already spoke to the contract holder. They were all closed. So yes, sir, the cat and mouse game of this happened after the fact and here you go. That's why you have to take each case, review each case, look at the paperwork, look at the probability of what could have occurred as opposed to what may have occurred. From there, you have to go out and press the flesh. You have to talk to people. You have to interview people. You have to educate them as to what's expected under the governing statute of 30C. Now, the best advice I can give to renters, when you come onto a property, try and observe. State law requires 24 by 30-inch signs with all the terms and conditions of what's expected of you in order to park on that property. If a permit, a visitor, resident permit is required, please display that. If you're compliant with the terms and conditions of the sign, which is expected at the entrance and one for every 45 spaces, one would hope that all the parties involved will play by the rules in a perfect world and towing wouldn't be an issue. Now, what another catalyst for the uptick in towing that we've seen is a lot of properties countywide were built in a time where a family might have one car, maybe two, at least when I was a kid, right? Now we see households with 3, 4, 5 cars, but yet you have one assigned space and one visitor space. Well, mom, dad, little Timmy, and little Sally, and cousin Billy, now there's 5 cars per household, but yet you're only given 2 spaces. What do you do? What do you do when space is running out and the terms and conditions aren't always followed to the letter of the law? That's where you have to become a little clever. You see the bigger picture of what's going on here. And you simply have a friendly conversation with someone. Having a simple conversation with the management office, they'll tell you everything how it works. And if they say the tower takes care of everything, that's a huge red flag.
Right. Well, fortunately, in most cases, we're particularly interested in those people who have a right to park there and are
Yes.
being towed when they shouldn't be towed. But one
Absolutely.
thing, Bernie, can you tell us, let's say a tow truck driver is about to tow or has hooked up your car. What rights does the owner of the car have to, for example, demand that they see the authorization, to demand that no further towing take place until the police arrive? Are there any rights at the moment of tow?
Well, thank you for that question, first off, because you touched on two huge points. As Eric said earlier, if you interrupt a tow, and that tow has not gone off, I believe, above 12 inches, 6 to 12 inches off the ground, it's not fully hooked up, that should be a drop fee. That shouldn't be a completed tow.
Which is how much?
I believe it's $25. So it's not the 150, it's a reduced fee. That should be made available. Moreover, if a police officer, or if I'm remembering the statute correctly, a member of this office interrupts a tow and for a good valid reason orders the tower to drop the vehicle, that's also within the authority of uniformed police officers to disallow a tow. It's right there in 30C. So if those situations were to arise, there is remedy already in place. Now, if the vehicle is already hooked up on the back of the truck above, say, 12 inches, already fastened, already called into the PD, even before the process, then it should be 150. The tower normally would go to the lot to have you pick it up. In some instances, this might lead to a loop in which they say, oh, okay, I won't make you go back to the lot, but meet me around the corner. That's another red flag, because now you have someone who are a tower that could be using this as an excuse. I'm trying to save them an Uber ride. I'm trying to save them cab fare instead of having to come back to the tow lot to pick up their vehicle. Well, yes and no. Who's to say you're not picking up vehicles, parking them around the corner, simply to be able to ring the register a little bit faster? So when you look at a situation such as that, you look at when it was called in, what the paperwork says. If I went into my local coffee shop for a cup of coffee, anyone who knows me understands I love my coffee. I love the stuff. What was that, 5-10 minutes? So I go and get my espresso, no more than 5-10 minutes. I turn around, my car is gone. And I say, oh, meet me around the corner. I have your Chevy. Really? You're telling me you came from the tow yard and want me to go in less than 30 minutes? I can't even get a pizza that fast. The math doesn't add up. It just doesn't. So in those instances, I simply have a polite conversation with the tower, much like I would with the property, and say, this is a problem. This just doesn't smell right. And if it doesn't smell right, it's not right. And then I have to go through all the paperwork, every little nook and cranny, and see, did they meet the criteria of the statute in place? And it's either yes or no answer. And if it's a yes, okay, I'm sorry, vehicle owner. They fulfilled every letter of what was expected of them. But if it's a no, then we have something to work with. And if we have a pattern of behavior with the same tower or the same driver trying to exploit small little nuances, as Eric said, no law is perfect. Every law has its little nuance that can be pushed just a little bit. But if we see a pattern of behavior, this office can take action, and we do.
So, Bernie or Eric, what are the penalties for towing and breaking these rules? Are there obviously a towing reimbursement, but what else is involved if a tow truck driver or their company is in violation?
Well, let me just say, that's an excellent question. We have the authority to issue civil citations for violations, $500 or $1,000 if there's a repeat case. It's also, though, Matt, very important for consumers to know and for tenants to know. Besides, I know your organization is you do a lot in court. Well, consumers under this statute have the right also to go to small claims court where they can seek 3 times the damages, meaning 3 times what they had to pay if they're successful in court. So they can file the complaint with our office and with Bernie. Bernie does a remarkable job, as best you can tell, in terms of finding ways to get a refund for consumers, but they also have the ability to file action in small claims court where they can get more than just a refund of their money. But we do issue civil citations. We do take legal action against those movers who are in violation. And it's an amazing surgery, in essence, that Bernie goes through when he looks through the paperwork, the receipts, all the details, to find out if every single I was dotted and T crossed.
A couple process questions then also. Let me give them to all of them. You can answer them how you choose. One is, how long does this process usually take? Do you recommend that all complaints go through your office first prior to going to court? Should they exhaust the county's remedy first before they go to court, as we often recommend for tenants who have complaints with their landlords to go through the Office of Landlord and Tenant Affairs first? Is that your approach? And the third question is, you mentioned $150 cap on the tow. Is there a cap on storage fees if they hold your car for multiple days?
Well, it's $30 every 24 hours. Okay. So the longer your vehicle sits, the longer the storage will be. Now, if it reaches a point under the statutes, the tower is required to send out certified letters to lien holders, owners, any person involved. And then ultimately, after those thresholds are met, the tower has the ability to dispose of the vehicle, unfortunately. So,
can you give us an idea of what those parameters are? I mean, how many days, how much money are we talking about here?
They usually send out notice within 7 to 14 days. After that notice is given, certified mail to all the parties involved, then the vehicle can be disposed of. Now,
So they can sell the vehicle.
Sell it, send it to scrap, what have you. Most towers do not do it that quickly. I recently worked on a case where an individual had to leave the state for about 2 months. 2 months. And it occurred not only the tow, but also storage fees, approximately $2,000. $2,000. Okay, you're tending to family out of state. You come home, your car is gone, and you're looking at $2,000. The owner of the vehicle recognized, I parked in the wrong spot, but I wasn't expecting a bill for $2,000. So I looked at the paperwork, literally line by line, statute, covered up, went through each line. Noticed one small finite detail, the address. This particular tower has 2 offices. Everything was perfect on the invoice except the address of the tower, which was their Virginia office, not their Montgomery County office. So I told them both, goes, you admitted you parked where you shouldn't have. I respect that. Thank you for that. Tower, your paperwork isn't 100% correct. Both parties have not the cleanest of hands, but how do you want to resolve this? Both parties called me within 5 minutes saying, can we do a Solomon 50-50 split? We'll give back 1,000. We'll keep 1,000. Your car is saved. Within, I think it was maybe 3-4 days, we were able to resolve it for a car that was going to go to the scrapyard with a $2,000 bill on top of it.
Sounds like a good old lose-lose. So but back to the other 2 questions, process and court, should they go through you first? Do you recommend that to exhaust the county remedy first?
Well, if I may, Eric,
Sure.
What I say is I'd recommend exhausting the county first. We're here based on your tax dollars. We're here to serve the community. We're here for you. Okay, that's how I pay my mortgage, helping you out. So I say file with our office. We've been here since the 70s. We're going to be here for plenty more time. Come to us.
We hope. Right.
We'll go to bat for you. We'll do anything and everything to make it right. And if a situation arises where we can't make it right, then you go to court. Because when you go to court, the only ones who really win are who? Eric? Who are the ones?
The
The
attorney.
lawyers, right? The lawyers. They get a new Mercedes or they get a trip to the Caymans. You don't win.
Sometimes
So-
a one-way ticket.
That's a one-way ticket.
Okay, Mr. Friedman, is there anything else you'd like to add in this overview?
Well, really, let people know that the best thing they can do, if they have a question, they can contact our office and they can talk to our expert, Bernie. Many people know that Doug Numbers had been our former expert on towing. He has trained Bernie very well, and we're there to serve. So really, there's millions of questions that will come up, and Bernie's going to be there to answer every one of them.
Happy to.
All right, I'm going to put the link to the complaint in the chat. So I urge anybody who has this complaint, a lot of people just, we have a big enough challenge trying to teach people their rights about when they rent, let alone rights about towing. This is a large area that is a problem, and it's hugely expensive for middle and low income families, as you point out, Bernie. It can be devastating, when you're talking $200, $300, $400 or more to get your car back, especially if you need your car to get to work. I'm looking forward to having to deal with a tenant who's got 5 cars in the parking lot. I don't know that that's our biggest problem right now, but somebody who has 1 car that they rely on, and finding it towed without proper authorization is a big deal. So let me put the complaint link to the Office of Consumer Protection in the chat. And I urge all of the people listening not only to take advantage of it yourself if you need to, but to tell your neighbors and friends about this so that they can take advantage of what is something you pay for with your tax dollars and a service that is due to you. Staff, is there any questions or concerns for Mr. Friedman or Mr. Vega?
I think we had a question regarding tow drivers need to be licensed, correct?
Yes, ma'am.
Okay. And they have to carry that. Is there a license they carry in their glove compartment they have to show you?
If you're in the business of towing, you need to be licensed appropriately. You need to be insured appropriately. Those are the 2 main levers that are without fail a requirement.
Okay, thank you.
Looking at the Q&A here. Statement from the landlord that the tow truck driver has a right to use force to pull a gun out and scare you. What rights does the tow truck driver have to protect his or her tow?
Pardon, did you say that a tow truck driver is pulling out a firearm?
That's
I'm a
what
citizen?
somebody alleges. I guess it doesn't really matter whether it happened. We're not going to litigate any specific case here, but I do want to ask, what if, for example, you confront the tow truck driver, you say, hey, that's my car, put it down, let go. What rights does the tow truck driver have to proceed in that scenario?
Well, again, if it's interrupted before the tow is completed, they should be charging a drop fee. Now, if the tower is threatening any kind of violence, I would recommend contacting the police immediately, because that's a situation that could become rather dangerous, frankly. So if that is happening anywhere in the county, I would respectfully invite the constituent to please contact the police as soon as possible.
And would you recommend that if you think your car is being towed without proper authorization or illegally in the first place, to contact the police?
You could, so that it's documented, but what I would recommend is as soon as possible, file with our office so that we can begin the process and piece everything together and establish what exactly happened and how.
And we've often recommended and found this successful, as Mr. Friedman pointed out in one case we had a few years ago, of filming the issue and asking the tow truck driver if he has or she has the authorization that is required to show it, to say that they have it, but to document the tow, especially if you believe it is unauthorized or illegal.
Again, sir, now everyone has a camera and a video camera on their phone. It's the quickest way to document exactly what happened. So if there's no signs in place, you preserve the signage issue right there. If there's aggressive behavior, you preserve the situation right there. Everyone, for the most part, has a camera on their phone, and that is a very, very powerful tool nowadays.
To have evidence for you all if there's a complaint to be made. You mentioned, Eric and Bernie, that properties are expected to keep a log of tows that occur on their properties. Does the public have access to that information?
Yeah. The way the statute is written, uniformed police and or members of our office may walk into an establishment and request to see the log. Now, as we move more towards a tech situation, no one's going to pull out a notebook and have printouts for the past 12 months for the most part. Now, for the most part, what I run into when I first educate the property or the designee as to what's expected of them, share with them a physical copy of the statute in play. Also, take it a step further to highlight the point that under the statute, not only is the tower responsible, but the property has skin in the game as well. At that time, you can ask to see, show me how are you requesting these tows. A lot of times the property will simply pull up an email folder in which it has all the requirements. Please pull this vehicle, this tag for this reason. And it's preserved in the office desktop file under tows. And they ask for what day, what time, and most properties bring it right up and say, here it is, and this is the reason, and this was the time and person that requested it. That's in a perfect world. In some instances, I've run across situations where that's lacking, where that doesn't exist, and that helps facilitate a refund for the renter, for the vehicle owner.
Do you do refunds en masse if you find that there have been 15 tows at an apartment community and no log?
Well, if those 15 people have filed with our office, we had a similar situation like that during the pandemic, I believe. We reached out, we obtained the owners of the vehicles, and we produced refunds for the individuals that we're able to make contact with. So yes, sir, what you're describing is a situation that occurred, I believe it was towards the start of the pandemic. Just as things were closing down, it was brought to our attention.
So those of you out there who are listening, who live with these larger properties, who complain to us about towing, if you know your neighbors who have been towed, if you think that there's towing going on and en masse in your properties, as some of you have told us, you've heard your remedy. Contact the Office of Consumer Affairs. Let them contact the office and find out what log is going on because they know what they're doing. So let them do it. But if you feel that you've been towed without authorization, there is a remedy. On the other hand, for those of you who are renters, who find somebody parked in your space or who's parked in the handicap space when they shouldn't be, or is double parked and stays there all night or any of those things, sometimes people need to be towed. So, we do see the balance. But we understand that when you're not supposed to be towed, that it can be a really painful process, and there is a remedy for it. Is there anything else, Malek, Pat, or David, on this issue that we need to address with our two experts? Good. All right, then I really want to thank the director of the Office of Consumer Affairs, my friend who I've known for many years now, who is a real rescuer of people in trouble with consumer issues. The director of that office, Eric Friedman, thank you, sir, for coming. And Bernardo Vega, an investigator with the Office of Consumer Affairs, who's there to help, and he surely knows how to get it done. We thank you both. And unfortunately, we may ask you back down the road because this issue is not going to go away.
A pleasure. I'll be here.
Thank you both.
Thank you
Thank
for
you.
having us.
All right. So now let's move on to the second issue of the night that's near and dear to so many renters. And that is the COVID rent relief program. It was reopened again. The fourth phase of the program was opened, and people are waiting for their rent relief. We have with us the senior staffer for that program, Fernando Ortega. And Fernando, take it away. Thank you.
Yeah, thanks, Matt. Thanks for inviting me. And it's going to be hard to follow Bernie. Did such a great job with the towing stuff. So I appreciate that as well. Thank you guys, everybody, for coming. Just wanted to kind of talk about the program that we have in Montgomery County, just an overview of it and some of the ins and outs, and then we can open it up to questions. COVID rent relief. This is the fourth iteration. It's a grant from the Department of Treasury. So what we do is we help those who are facing eviction to help pay down some of their arrears. There's certain criteria that you have to have in order to qualify. That criteria is put in place because it is a program specifically for those who have been impacted by COVID. So that's the first criteria, is that you have to have some sort of COVID-19 impact, whether that's you had lost your job, you lost hours, you had, you weren't able to work for a period of time. There's going to be something that you'll have to fill out that kind of talks a little bit about that. And you have to kind of connect why you were behind back to a COVID reason. Again, this is because it's a COVID relief program. The other criteria is you have to be under 50% of annual median income for the area. And on the website, there's a chart that kind of talks about, what that is for how many family members you have. It goes up by how many total family members you have, but you have to fall under 50%. The other criteria is you have to have lived in Montgomery County since August of 2021. So that's pretty straightforward. You have to currently owe rent. And not only do you have to currently be behind in rent, what we have in place right now is that you have to have been 2 months behind as of June 30th. So we'll look at your ledger as of June 30th and see if you were 2 months behind at that point. Now, if since then you have paid, a little bit here and there, and they've gone back, and let's say, for example, they took some off of May, and so at this point now it looks like you're not 2 months behind. As long as you are continuing to still be 2 months behind, even though it's not, May and June, you'll still qualify. So that's where it gets a little bit tricky. What I would recommend is, if you think you may apply, apply. The worst thing that can happen is, we say you're not eligible, and then we give you some other resources that may be able to help you. So that's kind of the program. We don't have, at this time, we don't have a date as far as when the applications will be closed. We still have plenty of funds to go out. The last thing I want to kind of talk about too is just once you do get your application in, what we do is we don't quite do like a first come, first serve. So it's, you may have had your application for quite a while. But what we do is we triage those applications based on the likelihood of you being evicted. So those folks who have a judgment against them, maybe they have a red and white notice where the sheriff may be coming, those are going to be on our top priority, and we're going down from there. Our goal is to, eventually get to everyone. I completely understand that it's a very stressful situation, and not knowing what's happening, and if you're going to get approved for that is very stressful. But our staff is limited, so again, we're going from the most at risk of becoming homeless downward. Eventually, we will give you an answer whether you qualify or not. But that's kind of how we're doing it right now, to ensure that we don't have anybody entering the homeless programs. That's our goal, is to keep you housed where you're at. If that's not a possibility and you qualify, there's also some relocation funds available that we can help you with that.
Fernando, a common question's been coming up to us a lot about they applied and they were not 2 months behind when they applied, but by the time the caseworker gets to their application, they're more than 2 months behind, but then they get denied. Is it possible to extend once they are at the time of review to be 2 months behind?
Yeah, the reason why we did the June 30th is because we had closed the portal down, and then we reopened it. So the time frame that we have of June 30th is because if you didn't qualify as of the time that we had closed the portal originally, you still wouldn't qualify today, basically. If there is another iteration of applications being opened, then we would definitely take a look at that. But right now, June 30th is kind of the date that we're looking at going backwards. And again, if you were able, if as of June 30th, you did qualify and you go back and you have paid some of previous months, as long as you're still 2 months, in the arrears, that you may still qualify. But again, definitely, send in your application and we'll take a look at it.
So I guess I'm confused. Sorry, Pat, I'm just a little confused. If you applied and you were 7 weeks behind, and it took 2 months for y'all to get to the application, or 3 months or longer, and you get to the application, now they're 4 months behind, but are they judged on being 7 weeks behind when they applied?
They're judged by being 7 weeks behind as of June 30th. So as of June 30th, if they were 7 weeks behind, they wouldn't qualify under this iteration.
Wow. Any way to change that, Fernando? Can you snap your fingers, please?
Yeah. Right now there's not. Like I said, if we open up another iteration, it'll obviously be a different story. But that's kind of what we have as policy as of now.
Pat, did you have a question?
Yeah, some of our listeners want to know they have already received some COVID money, but they still need additional funds. Can you suggest some other than, I know you have other rental assistance programs. Can you give these listeners some suggestions about what they should do or where some resources are that they can go to?
Yeah, I think two things. One, if they've already gotten some funds, they still may be eligible for more funds. It kind of just depends on where they fit as far as the annual median income, and if they've exhausted either their total funds that they're allowed to have under the program or the amount of months. And again, that kind of depends on AMI. I would ask them to definitely apply still to see. And if not, definitely call 311. They have resources there. HSS at montgomerycountymd.gov. They have resources that they can be given as well. So that's kind of where I would go. I'm not really an expert on the different housing programs that we have in Montgomery County or other of our nonprofit partners have. But if you give that number a call or that email and send that out, they can definitely give out those resources.
Yeah, let me just caps a little quick summary here. The COVID rent relief program obviously is a federal program that was granted to the states, who then in turn granted it to the local municipalities. Montgomery County got a certain tranche of that money, but it is only for those who were impacted by the pandemic loss of income because of the pandemic or some other issue that made you behind in your rent because of COVID. So that's what that program is for. The county has a department called Services to End and Prevent Homelessness. They have some money for other purposes, including moving expenses, emergency shelter expenses, utility expenses. I would urge everyone to call 311 to find out about what you might be eligible for if you find that you are in a difficult financial situation and at risk of losing your home. The Office of Landlord and Tenant Affairs also has some emergency funds available, rental assistance program. It is far less than what is available with Health and Human Services, but some people just need a little bit of help now and again to get them through a difficult period. There are also nonprofits. The Renters Alliance is on the board of the Emergency Assistance Coalition. That is a coalition of nonprofits. We do not, but we certainly monitor what is available through other nonprofit charities that offer funds. That Emergency Assistance Coalition is under the umbrella of Interfaith Works, which also manages the homeless facilities in Montgomery County. So interfaithworks.org is also. David?
Yeah, I think it might be a good time to mention that if you live within the city limits of either Gaithersburg or Rockville or Tacoma Park, those municipalities have their own separate funding that is sometimes not tied to COVID, but also to help pay rent. And so if you want help connecting with any of those specific municipalities, please, again, reach out to us.
Good, very good. Okay, any questions out there, staff, for Mr. Ortega?
Just to clarify, Fernando, if someone applied for a previous, say the second round of COVID to get additional funds for COVID relief, they have to put in a new application, right?
Correct.
Okay.
We won't confuse everybody too much, but just so for anybody who really has been paying attention to this, this is the fourth phase of this program. The portal closed in the past, was reopened with a new portal system for application, an electronic system. Fernando, when did that open? Was it was May?
Yes, I think originally it was May, and then we closed it. We're still, that was also the fourth iteration. We closed it, and then we kind of reopened the fourth iteration again the first week of July, I think it was.
Right. So as it stands now, the fourth phase of this, the additional funds that came in, is available. And I put the link in the chat. If you think that you've fallen at least 2 months behind in your rent and because of COVID, we urge you to apply. That's what the money is for. People say this is, some have complained that this is unfair because the renters are getting these subsidies. Well, these subsidies are going to the landlords to help renters. So this is a win-win if you are eligible for it. That's what we pay our taxes for, to keep people stable and housed. What else, folks?
Well, I don't know what Fernando can do about this. There's still a lot of frustration in the chat about people who have applied back in June, who do qualify, who have kids, and are not hearing anything back. I guess the question is, what can he do to escalate that?
Yeah, I would say, first of all, I completely understand where you're coming from. Keep the application updated. So if anything changes, such as you get a judgment, or you're in a situation where you have a red white notice, please get that to us, email that to us, call that number, let us know so that we can expedite your case and get your case approved, so that you don't end up homeless. I understand if you're not quite at that situation yet, or it's still very scary. It's a scary situation. It's a lot of unknowns. Especially when you have kids. I totally understand that. But again, we're working from basically the top down. But again, if anything changes in your situation, please upload those documents, get in touch with us at HSS, and we'll go from there.
just to remind everybody of Montgomery County MD.gov, sorry, there we go. The escalation process they need to know. The COVID rent relief program needs to know. So if you've just gotten a notice to vacate from your landlord or their lawyer, that's not as serious as receiving a court summons. A court summons will be a yellow summons on your door that gives you a date in court. Sorry, why am I so famous tonight? Sorry. That's the first thing. The second thing is that once you go to court, once you go to court, right. All right. Sorry, I'm also a victim of a key scam, which is very interesting. People calling me saying they found my keys all over town. This is my night. So second thing, you received a court summons, you go to court, and you have a judgment against you. All right, that means you haven't paid up. The judge will stamp that. HHS needs to know that. So take, a copy of that and email them at hss@montgomerycountymd.gov. HSS, it's counterintuitive, but it's hss@montgomerycountymd.gov. If and when, God forbid, you get a sheriff's notice, which is a red and white notice that will be stuck on your door, that says that your eviction is imminent within weeks. They need to know in order to prioritize your application. So make sure that you let them know at hss@montgomerycountymd.gov that you are facing imminent eviction, and they will, as they promised, prioritize those applications. The Renters Alliance feels you and understands the frustration and have advocated to start burning the other end of this candle to get you all funds earlier. We're all wearing I'm a renter and I vote buttons. Make sure that the people you vote into office hear your concerns and give the proper support to our government agencies so that they can do their jobs faster and with greater support. So that's where we are right now. What else, folks? Is that it? Then I'd like to say again to Mr. Ortega, Fernando, thank you for coming. It's very important for our renters, and there are nearly 400,000 renters in Montgomery County. We've got a number of them on this call, but we represent tens of thousands through the Renters Alliance. Every time we send out a newsletter, we urge people who are listening to this Renter Town Hall to tell your friends and neighbors about these services, about the COVID rent relief program, and of course, the Office of Consumer Protection. If you need their assistance, particularly for towing, but other issues that they have outlined. We do have buttons available. Somebody put in the chat and just send us an email, info@rentersalliance.org with your address, obviously, and we will get you I'm a renter and I vote buttons. And now we will take any other questions or concerns you might have about renting. If you have any other issues, now would be the time. We'll give you a couple of minutes if you haven't put it in the chat or a question, but staff monitor, see if there's anything else we can address.
We've got to please clarify the June 30th date. Does this exclude delinquency from July 1st to date? And if I recall what Fernando said, there is some flexibility there. And it sounds like it's worth putting in an application now that the portal is back open. But I will defer to you, Fernando, on that.
Yeah, I think in any case you want to put in an application and let us, give it a look. We've also, created a program for being able to take a second look at it. We're all human, and sometimes folks, my staff will make a mistake and erroneously deny somebody. If you think that you're in that boat, when you get that denial letter, there'll be a way that you can request a review. And we have a review program now in place that they didn't have before. So again, I think it's just the most important thing is just to apply. Again, worst case scenario is we say no and we say, hey, we can't help you, but here are some organizations who may be able to.
No, thank you for that.
Other questions?
We also had a question about an increase, a rent increase, and then also as related to someone with who has a voucher and how much they're allowed to increase. So I think I just wanted to throw out, please let us know, and also I can put the ulta.intake if you feel like it's an unreasonable increase. They want to know about it at the county as well. So I'll put those emails in again.
Also, once someone wants to know, can they get their apartment painted after 5 years? And I think the rule is that you can have your apartment painted after you've been there 5 years.
That's correct. Let me, thanks, Pat. 5 years, you have to request it, okay? And if you've got furniture in there, you have to prepare your apartment to be painted. They don't do that for you, but they will, by law, be required to paint your apartment or part of your apartment if you request it after 5 years. Let me distinguish that from carpeting. You do not have a right to have your carpet replaced every 5 years yet. We'd like to see that changed. Maybe not every 5 years, but certainly after normal wear and tear. Some people live in their apartments their whole lives. And after 10 or so years, that carpet can certainly look terrible. But right now, there is no right to replace it. There is, however, a requirement that if through normal wear and tear, the carpet becomes a tripping hazard, it is a code violation. And the code inspectors will require the apartment to either fix it or replace it. If, however, you cause the damage to the carpet and it becomes a tripping hazard, then you will be responsible for fixing it. So just separate the idea of carpets with painting. Painting you are entitled to have every 5 years if you request it. Make sure you request everything like that in writing. What else we got?
Fernando, just real quick, I think you might have already answered this, but I'll ask it again for their information. So if anything has changed, you had 2 court summons, for instance, they need to update their application for COVID rent relief, correct?
Correct. Yeah, there's a place where you can upload documents. If you're not able to figure out that or the site's down, you can always email them to us. But yeah, they need to go ahead and get that to us, because then we kind of we can possibly get them towards the front of the line if they're in more of immediate risk of
so does it move up on the list? How does that work internally?
So basically what it is, so we have what's called urgent teams. When it gets to a certain point or we get new information, we get aware of it, we'll send it out to the urgent team. If it's a red and white notice, like it's a sheriff's notice, those ones that are absolutely urgent, we'll give to that team. If it's a situation where they have a judgment, and there's some other factors as well, I will, or one of my staff will assign it to somebody specifically to go through and take a look at it and see if they qualify or not at that point. So again, that's kind of how we're doing it, kind of a step process, but we're triaging it just like an emergency room would or anything else.
Perfect. Thank you.
And just to throw in, at the court there on the 4th floor, right where the court is for this, just 2 doors down is a woman named Bethlehem, I believe, from DHHS, who is there, will literally scan and upload that judgment on the spot. And then, but if not, we put the HSS at Montgomery County, Maryland in the email there.
I saw a question which is near and dear to my heart, having been sued for this and won. It was the issue of utility billing. You are entitled to review the bill that the landlord receives. The ratio utility billing system, RUBS, applies to apartment buildings where there are no individual meters, particularly for water and sewer or electricity. If the apartment community decides that utilities are no longer included in the rent, then they have to choose between formulas, the ratio utility billing system, RUBS. And that usually they have 2 choices in a formula. One, is square footage of your apartment. The other is a formula of a percentage that the apartment community is responsible for, usually 25 to 35% for common area usage. That is the public bathrooms, watering the property, taking care of the pool, wherever public usage takes place. And then the remainder is divided among the number of heads living in the apartment community. They have to keep a tally of who they're charging. So it could be a fractionated because some people might move out in the middle of the month, but they have to keep those records. You are entitled to receive that data within 30 days if requested in writing. If they don't provide you that information, as they didn't with me, big mistake, then you should file a complaint with the Office of Landlord and Tenant Affairs at ulta.intake. They cannot charge you more than $1 per bill. Now, if there's multiple utilities being charged on the bill, they can charge you for each of them. That's my understanding. I'm willing to be proven wrong on that, but I think if they're charging you water and electric, they can charge you for water and they can charge you for electric $1 each. But if it's one bill for water, they can only charge you $1. If you're being charged more than that, you should file a complaint with the Office of Landlord and Tenant Affairs and let us know. I'm pleased to say that what we've heard from the Office of Landlord and Tenant Affairs and their new director, manager Nicole Catravanos, that they're taking an approach that we've urged for some time that we like a lot, which is an administrative enforcement approach. So that if they receive a violation that appears not to just be an individual violation, but possibly an indication of a community-wide violation, like receiving bills for utilities that are illegal, that is, charging you more for a utility bill than they should, or charging a fee for producing the utility bill that's more than is allowable by law, that would suggest that it's happening not just to one person, but to the whole building. And they will take that approach of looking at the entire building's situation. So that's what I know about the law on that issue. There was a request there, a question we did not answer. David, did you find that? Somebody said to get to the question I didn't get answered.
Well, no, the one I would, yeah. How can there be kind of these mistakes in processing of these applications? And I'll just say I've actually had a little experience in Fairfax County too with this high volume stuff, and there's just going to be mistakes. But the important thing is that I've found they've been responsive when there's a discrepancy. So please do let us know if you're not hearing back from a caseworker about reopening a case or something. Let us know, because they in our experience they have been receptive. That was the one question I saw there. And then also but is there an income limit for the renter's tax refund? Yes, and I believe it's lower than the there's a ratio, but I believe it's often lower than the rental assistance threshold. So just be aware of that.
Let me just address quickly, Fernando, jump in if I'm wrong, but you are not able to release names of people who received COVID rent relief. I'm assuming that's private.
Yeah, we can't do that. It's
right.
Protected.
I suppose if somebody wants to sue the county and demand it through a subpoena, they could possibly get it through the Freedom of Information Act, but you'd have an uphill battle.
Yeah, that'd be good luck, but yeah.
Right. Seriously, people who have had these difficulties don't want necessarily to advertise. You can have to respect their privacy to want to receive assistance. People are proud, and it can be a very difficult situation to have to receive government assistance. We, of course, all of us want to work and receive the funds that we get from our work, but sometimes we're down on our luck, but we don't like to advertise it. So it's private for a lot of reasons. And also, we are afraid at the Renters Alliance that certain information about tenants, whether they've received government aid or whether they've made a complaint or they've talked to us, could be used against them by landlords who look to see whether or not they've had these issues in the past. So we also guard tenants' information zealously to keep it private. Anybody else got a question for us, folks? Looking through real quick, going once. All
Did
right.
see a question about mice, which I would refer to. Is that, should I put a code enforcement link out in the?
Please
just
do.
In case, okay.
Let me quickly say, there are two different departments for enforcement as a reminder. The Office of Landlord and Tenant Affairs enforces your rights, enforces the provision of leases. So if you feel that your rights have been violated, if you feel that the provisions of your lease are not being enforced, if you have a general dispute with your landlord about the quality of life in your building or some such thing, contact us. We're happy to give you some advice and tell you whether or not to escalate this to a formal complaint. We help the Office of Landlord and Tenant Affairs by doing some buffering and educating tenants about their rights and responsibilities and the limits of those rights. However, if it gets serious, we would urge you to file a complaint with the Office of Landlord and Tenant Affairs. Likewise, there is an Office of Code Enforcement. Code enforcement is responsible for enforcing building codes. So that includes if your appliances don't work or are broken, if there are leaks in the building, if there's visible mold or mildew, and if there's vermin, mice and rats and cockroaches. Obviously, we expect you to do as much as you can yourself within your own home to keep it clean and be responsible. But at some point, these issues become the landlord's responsibility, especially broken appliances and leaks. And you should contact your property manager or landlord first and request and then demand that they do the fixing that they're supposed to fix. And if they are not responsive, then we urge you to contact the Office of Code Enforcement and file a complaint to get it fixed. They can be cited for failing to do that. And did we put that link, those links in the chat, folks? Good. All right. Well, I think we see some 8:30 faces on here, so I think it's time to begin to say thank you to everybody.
I just want to
Yes,
repeat again, please, everyone, do not forget to vote. Tell everyone you know or come in contact with to vote. It is important that we get as many legislators who are sympathetic with rental stabilization. So please vote. It's very important. We need all the help we can get.
Indeed. Thank you, Pat. Very important. And just so everybody knows, I believe that our October 12th will be our next renter town hall, and we will have Dr. Zelaya, who is the information officer for the Montgomery Elections Board, who will give information on voter registration, voting places, and other issues having to do with voting. And of course, he will repeat what we keep saying, make sure that you register and vote. Renters,
Yeah.
we were formed in good part to give renters an organized voice in public affairs. We were the first group to do that, and we want to make good on that mission. Elected officials and appointed officials are hearing more and more each year that renters are part of our community, that they're a large part of our community, and that we have an important voice, and that we all prosper when we have stable, quality, affordable housing. So with that, if there is nothing else, folks, is that right? Then let me say thank you again to Eric Friedman, Director of the Office of Consumer Protection, Bernardo Vega with the Office of Consumer Protection, and Fernando Artega from the COVID Rent Relief Program for your service and for being here tonight to inform our community and of course our staff, David Mullins, Malek Demir, and Pat Beckham. And with that, well, I'm Matt Losak. Good night.